Welcome once again to Lehto's Law. Here's Steve Lehto.
Michael sent me a note. Steve, did you see the story in the riverfronttimes.com? I said, no, I hadn't, but thanks for sending it. Former prosecutor says Kim Gardner's top staff filed dismissals using my name. And what we're getting at here is that lawyers routinely sign documents. And we sign documents and submit them to the court because we're required to by the court rules. And the court rules are quite specific on how your signature needs to be used, when it's required, and what the ramifications are of misusing your signature or not using your signature in the proper ways. So this is a bizarre story, and the woman speaking here says the totality of it was crazy. And she's talking about her time that she worked in that prosecutor's office, the top prosecutor. So Ryan Kroll wrote this story after interviewing the woman. Former assistant prosecutor in St. Louis says that top staff working for the St. Louis Circuit Attorney Kim Gardner regularly make court filings on behalf of lower-level attorneys who have no idea what's being filed under their name and bar number. So when I sign a complaint, a lawsuit that I'm filing on behalf of somebody else, my client doesn't sign the complaint. I do. I sign the complaint, and I sign it with my signature. There's a bunch of other information I got to put in there. And also my bar number gets included, which is the number that indicates that I am, in fact, a member of the Michigan State Bar. So somebody could glance at the list of attorneys in Michigan and go, oh, yeah, the guy's an attorney. Okay, cool. So the woman who resigned from the circuit attorney's office on Friday says that among the filings made by executive staff are noli prosequi, filings that were dismissing cases without the knowledge of the staff attorney handling the case, even though the staff attorney's signature was put on the paperwork being filed. And this is being done with, I suspect, electronic filing. So when you file something electronically and you sign it, you don't actually take out a pen and paper and sign it. It's an electronic signature. And I assume you've encountered those before. And generally speaking, it's quite often that you simply type your name in a spot that says type your signature, and then you put in your bar number and you hit enter, and that's a signature. So when you're filing things electronically, you still use your own name for your signature. You don't use the name of somebody else because that kind of defeats the purpose of having a signature on the electronic document. So she said that one of the craziest things was always that the executive staff would decide that things needed to be filed, and they would be filing it under our name without us ever knowing or allowing them to do it. And that is a problem. There's no question that the court says an attorney files a document that's filed with the court. So if the court has a problem with that document, they know who to call to task for it. So her allegations, which were shared with the Riverfront Times in an interview yesterday, could become a complication for Gardner as she seeks to head off a removal petition from the Missouri Attorney General. Now, Gardner has argued that under the law governing quo warranto actions, like the one brought here, she can't be held responsible for the actions of her underlings. And so if what this woman is saying is true, that her signature is being used without her permission, then it would look like people above are doing this perhaps to somehow evade some kind of problematic situation. And so the woman speaking to the reporter says that top staffers regularly make court filings using the signatures of other attorneys. And that would be a no-no. She cites as an example the relatively high-profile but short-lived case back in December when a woman was charged with robbery and armed criminal action for allegedly trying to carjack an alderman a few days before Christmas. It turns out that Facebook live stream of the immediate aftermath became a story in itself. And so this is a very serious allegation. And when you see people doing strange things, sometimes you have to step back and go, why are they doing that? I have filed in court thousands and thousands and thousands of documents. Thousands of documents. And I've signed them all. I've signed thousands and thousands of documents with my name, signature, bar number, all that information. I do that. And I've never filed anything with someone else's name on it and signed their name to it without telling them. I've never signed it with telling them because I found my own documents. Okay? So this is such a strange allegation that it is bizarre. And it makes you wonder if somebody would do that for any other reason except the obvious one. And that is that they want these documents filed, but they want to be able to say, oh, it wasn't me. It was filed by one of my underlings. And now the underlings are saying they're using our signatures without our knowledge. And at that point, it's no longer a signature. See, a signature, if you look it up, is when someone does something, usually signs their name, but when someone marks something in such a way to indicate that it is in fact their signature. You may have heard in the old days where someone who was illiterate would be asked to place an X on something, and that would be witnessed. And their name's not X, right? But the point is that if it's intended as a signature, then it gets that kind of treatment. So if someone signed an X in front of witnesses, people say, yeah, I saw that guy or gal. I saw them draft the X on the document. That's their signature. And that would be perfectly legal. And so a signature by somebody else, by definition, is not a signature. Unless you gave somebody permission to use your signature in such a way. So let's suppose that I was in a horrific car accident and I lost both my hands. And I'm in a hospital bed. And I'm drafting, having somebody draft a document for me. I'm dictating a document to them. And at the end, I say, I want you to sign my name to that. Technically speaking, that would be my signature because it's done with my permission at my direction. So if I want that to be my signature and you sign my name to it with my permission and I'm right there, that's fine. But the court rules that address the signatures of attorneys are quite specific. And the courts don't want documents filed with the court that, number one, haven't been vetted by somebody with the ability to do that. But also, they don't want stuff filed where somebody might come back later and go, well, I didn't sign that. I know it's my name, but someone else signed it. And that's what the court's trying to avoid. The court's trying to avoid exactly this situation. So I went and pulled the Michigan court rule because I knew it was handy. MCR 101E sub 5. You can pull out your own copy and follow along. Effect of signature. Effect of signature. The signature of a person filing a document, whether or not represented by an attorney, constitutes a certification by the signer that he or she has read the document. So if I sign someone else's name to a document they haven't read, by definition, I am completely violating the spirit of that rule. But that is simply A under 101E5. There's a few more here. It also is a certification, and by the way, it's a certification. It's not just a signature like at the end of a note, hey, Bill, pick up milk in the store, Joe. That's a signature, but it's not a certification. In court, the signature acts as a certification, which means that the signer is not just putting their name on it, but they're actually making a statement about the quality of the thing that's being filed. It's a warranty of sorts, believe it or not. They're also certifying to the best of his or her knowledge, information, and belief, formed after reasonable inquiry, that the document is well grounded in fact and is warranted by existing law or a good faith argument for the extension, modification, or reversal of existing law. So you've read the document and you are vouching for the contents, that they are well-founded, etc., etc. So if I sign someone else's name to it without their permission, by definition, I am not doing that, and neither are they. And so when the document gets submitted to court with the wrong signature on it, well, it's in complete violation of these rules. Again, these are the Michigan court rules, but I'll tell you right now, these court rules are drawn from a variety of sources, and there are similar court rules in almost every state. So I assure you that in this situation, these allegations are serious. Likewise, the person is certifying that the document is not interposed for any improper purpose, such as to harass or to cause unnecessary delay or needless increase in the cost of litigation. And then finally, sanctions for violation. Sanctions for violation. So this is a serious rule for which, if you violate it, you can be sanctioned, at least in Michigan. If a document is signed in violation of this rule, the court on the motion of a party or on its own initiative shall impose upon the person who signed it, a represented party or both, an appropriate sanction, which may include an order to pay to the other party or parties the amount of the reasonable expenses incurred because of the filing of the document, including reasonable attorney fees. So there is potentially serious consequences for violating the rule regarding the signature on a legal document filed with the court. So this is a serious allegation. It'll be interesting to follow up on it. I'm suspecting that the bulk of these filings were electronic, which means that somebody was sitting at a computer, pulled up a document, signed it, and then submitted it to the court. And so if the court file is pulled up at the court end of it, they'd see a document that shows a signature of, for instance, this woman who spoke to the reporter. And now the woman says, I didn't file that, I didn't sign that, I never saw it, didn't know about it. So the question is, who signed it, who submitted it, and what right did they have to do that? And I hope they can track these things, because they might be able to tell, for instance, what computer it came from or what system it came from. They might be able to figure these things out, but that is a very serious issue. And so again, like I said at the very top, when somebody does something strange, you have to ask yourself, why are they doing that? Especially if they're violating court rules on what they're doing. So again, I did not look up the specific court rules in any other state, but in Michigan, and this is going to be true in a lot of places, if you sign a document, you're making a certification about the contents of the document and so on. But obviously, if you sign someone else's name to the document and they haven't looked at it and are unaware of it, then you've got a very serious problem. And some might argue that you are attempting to perpetrate a fraud on the court. And by the way, the noli prosequi, what they're talking about, is a Latin term, and it literally means that they have dropped the prosecution of something. So if you go to court and you've been charged with something, the prosecutor looks at the case and goes, you know something? There's no evidence here. We got nothing. We'll just drop the prosecution. And so they file that with the court, and sometimes it's called a nolle pros, because that's what the hip kids are calling it. The nolle pros on TikTok. The nolle pros, or a noli prosequi, but that is where they drop the charges against somebody. But you should know that simply dropping the charges against somebody does not mean that person will never be charged again with it. Because if they drop it now for lack of evidence, but evidence later crops up, they can usually refile it unless they filed the nolle pros with prejudice. So you can file things in court without prejudice, which means that you've filed it, you've withdrawn it, and you've withdrawn it without prejudice, which means that your withdrawing of it does not prejudice or affect your ability to refile it in the future. But if it's withdrawn and nolle prossed with prejudice, it means that you are prejudicing your ability to bring these in the future. So I know that this often happens where parties will be fighting over this, and the prosecutor goes, fine, we'll nolle pros it, right? And they go, well, nolle pros it without prejudice, which means they can bring it later. And I've seen these arguments take place where people go, I want it dropped with prejudice because I don't want you to bring the charges again in the future. And the prosecutor says, yeah, but we're dropping the charges now because we haven't got evidence. Who knows what's going to happen in the future? So I would suggest that if they offer to drop the charges, let them drop the charges. And if they refile them later, deal with it then. But quite often, when something's been NP'd, as I like to call it, a lot of times it's not ever revisited simply because it just seems like you're going back and rehashing something. But this is a case where the woman in the story says the totality of it was crazy, referring to former prosecutor who says Kim Gardner's top staff filed dismissals using my name. So there you go. From the riverfronttimes.com, Ryan Kroll wrote it. And Michael sent it to me, said specifically, Steve, I don't use Mike, I go by Michael. And I respect that. If you go by Michael, I will call you Michael. Thank you very much. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. It's never too late to have a happy childhood.